Good morning. It is February 19th. We are talking about S44 and we have Pelko Schilling from the ACLU to provide some testimony. Floor is yours.
Thank you so much, and thank you for the opportunity to testify this morning. For the record, my name is Pelko Schilling, and I'm the advocacy director for the ACLU Vermont. It's legitimate. Make sure the whole committee gets to be here. So once again, I appreciate the opportunity to testify on this bill. I was able to listen to the introduction earlier, and want to say that the ACLU fully supports the intent behind this bill. A little bit of the history I think you heard before is this bill is looking at amending Act 5 of 2017, which was a bill that was passed in response to some of the actions from the first Trump administration, signed by the governor and passed with bipartisan support to try and provide some additional protections to Vermonters, specifically withholding the sharing of information to put people onto a registry, specifically looking at religious practices and then other identifying information. And as we, after the results of the election this fall, the ACLU, as we do with any incoming administration, took time to assess what potential threats to civil rights and civil liberties might be on the horizon, and looked at state laws and protections around the country that might be able to better protect the civil rights and civil liberties of different individuals. And so here in Vermont, one of the obvious starting places, what have we done before? And we thought it'd be good to look at Act 5 of 2017. And so what you see in front of you today, the testimony I submitted last week, is a series of proposed amendments to Act 5 to strengthen it, to address some of the emerging threats that we have seen to folks.
I don't think we have. Did you send that to our?
I sent it last week. Unfortunately, I had to delay the testimony, so I don't know if you have that in front of you.
Mm-hmm.
So would have been
printed?
Yes.
We'll just get that printed, but yes. Sorry.
I'm happy to walk you through it and then speak a little bit more to the underlying bill, because there's not a lot of overlap between the bill as proposed and our proposed amendments to it. This is something we've talked with a number of different lawmakers about prior to the session and wanted to put in front of folks since it does deal with the same underlying statute that S44 looks to amend. And so in essence, the changes that we're proposing to Act 5 and would hope to incorporate into S44 would be to include additional categories where information sharing collaboration would be limited with federal government and with other states. And those main categories include imposing civil or criminal liability for either providing or receiving legally protected healthcare within the state of Vermont. And so legally protected healthcare is something that's defined under our state law to include both abortion care and gender affirming care. Would also include any other sanctioned medical practice that folks might be, or medical procedures might be giving or receiving under state law. So that's one of the additional things. I think that in many ways could almost be a cross-reference to our existing SHIELD laws, but thought it would be helpful to have this in one place as folks are looking at the categories of information where they should be concerned or might be limited from sharing or collaborating with federal authorities for information requests. And I will say, as our field laws are currently written, they largely envision concerns around collaboration with other states. States like Texas, which have bounty hunter laws and are trying to reach beyond their borders to regulate activity that might be lawful here in the state of Vermont. We have not seen any movement on the federal level at this point in time that would change that landscape beyond Supreme Court decisions, but we don't know what the future holds. And so I think there are some concerns about what enforcement could potentially look like from the federal government, but I think this largely speaks to other states who might be trying to initiate prosecutions for folks, for instance, coming to this state to receive abortion care. So that's sub A within the proposal that I put forward. Sub B is prohibiting information sharing or collaboration with investigations into protected First Amendment activity. This is something that is a concern to us in particular as the American Civil Liberties Union, because protecting the First Amendment is one of our core functions as an organization. And it's something that is of great concern when we look at potential crackdowns on protests. And this, with some of what you've been seeing in the news over the last couple of days, where you have top administration officials calling for DOJ prosecutions and investigations of elected officials for simply providing things like know your rights trainings, which are fully protected under the First Amendment. And so it'd be a great concern to us if we were to be seeing Department of Justice or other federal entities looking to try and prosecute or otherwise sanction folks for just exercising their First Amendment rights, whether it be providing legal information, whether it be engaging in peaceful protest. So that's another area where we'd be concerned about trying to limit information sharing and collaboration with the federal government. Beyond that, the last three sections speak to sharing information to help further the investigation or imposing sanctions for violations related to immigration law. This is something that is embodied in some of the work that we've already done as a state. And I think it speaks to the underlying intention of this bill, which is to try and limit things like mass deportation efforts and other things like that. Some of this is also embodied in our fair and partial policing policy we passed as state laws, such as laws we passed that prohibit ICE arrests at courthouses, because there's a major concern when state and local authorities become involved in federal immigration enforcement. And it is our choice as to whether or not we want our state resources and our local resources to be used to further those enforcement activities, as opposed to being focused on enforcement of state laws and state violations. A major concern there is, trust being built between the government and with law enforcement officials. And we think by passing this bill and by further limiting that information sharing, that can help bolster even more trust between immigrant communities and law enforcement and others. They're one of the major concerns we talked about when passing the ICE arrested courthouse bill was the fact that when you have local law enforcement involved in immigration enforcement, immigrant communities are less likely to report crimes. They are less likely to provide witness information regarding crimes. And we want these or to engage in the legal system generally. And so we want to make sure that these folks feel like they can fully engage in our society without fear of local officials then turning into an arm of federal immigration enforcement. So those are kind of the three major categories of information sharing that we'd like to see limited. And as you'll see in here, there's also a section that tries to lay out some of the assessment procedure that we would hope the governor's office would engage in trying to determine whether these requests were legitimate or ones that they should comply with. In essence, we are not asking anyone to violate any existing laws under this bill. We are trying to ask folks to withhold resources where it is legal, and then to an assessment of where there might be statutory constitutional obligations, and then respond in kind. And one of the concerns I heard about this piece of legislation when it was being discussed last week was compliance with 1373 and other federal statutes, which prohibit, it's kind of confusing, but they prohibit state and local localities from prohibiting communication about immigration status with federal authorities. And so I think there's an explicit carve out within this piece of legislation, which says that's not what this is trying to do. It is not prohibiting that type of communication. And if those types of requests were received by state authorities, that they would not be prohibited from relaying that information. A little bit of background. This is an issue that's been under debate across the country in terms of the enforcement mechanisms around 1373, where this was initially tied in an effort to limit almost all federal funds that was blocked by the courts. It is then been tried to Department of Justice JAG funding, where a number of circuits found that was an impermissible way to restrict funds. The Second Circuit was an outlier in those decisions. So it's unsettled laws in terms of what actual enforcement mechanisms the federal government might have around trying to compel some of this information sharing. But as drafted, the intent is to go up to, basically to ensure that we are not in violation of federal law, but that we are limiting the use of state resources to the greatest extent possible to offer greater protections to people here in the state of Vermont. And then I think the final section of the bill that I want to speak to is subsection B of section 4652. And this is something that our proposal has in common with S44 as drafted, which is the elimination of the carve out related to federal and state emergencies, where it says that collaborative agreements can be entered into when there's a either state or federal emergency declaration. And that though in that situation, folks seeking to enter into that agreement would no longer need to seek authority from the governor with a consultation from the attorney general in the current underlying statute. That's of concern to us because since the start of this administration, we have already seen a couple of states of emergencies declared. The closest one related to anything we're talking about today would be the state of emergency at the southern border related to immigration. I do not think that that state of emergency would create a situation where someone would say, well, there's a direct relation to the public safety and welfare of the residents of Vermont arising out of this, but that's my interpretation. And others might say, well, since that is an emergency declaration related to immigration, I think we're fine to start entering into these collaborative agreements without bringing that up to the governor and the attorney general under current law, or under the proposed bill without having to bring that to the legislature as well. So that is a concern because it is something that undermines the effectiveness of the bill of current law and I think what folks are trying to achieve with the proposed amendment. Speaking to the proposed amendment and the addition of the legislature as a check on whether or not agencies are entering into these collaborative agreements, we would support that. I think it's not something that we originally envisioned in terms of the proposals we put forward. We were more focused on some more substantive limitations on information sharing, but could see that as a helpful check in terms of getting more eyes and more information in front of folks about when these agreements are being entered into and the reasons for it. I do understand some of the concerns that might arise from the fact that the legislature is not in session some of the time, and that might hamper the ability to expedite these things. But I think we would be supportive of the language of the bill as introduced as related to adding an additional check on when these agreements could be entered into. So I think at a high level, that's what I wanted to share with the committee. I hope you'll consider our proposed amendments as you continue to work on this bill, and I'd be happy to answer any questions.
Committee, any questions? Senator.
Yeah. Morning, Falco. I believe that you had mentioned fair and impartial policing policies along with those individuals who may hesitate to call law enforcement because of quite possibly their status here in Vermont. I was part of the FIP back in the day, and I believe ACLU was there, and I think it was Jay Diaz at the time. And protections were offered during that time span in reference to victims of a crime or witnesses to a crime were protected under this. Has something changed because ACLU signed up and said, yeah, that's good, that works for us? But you're saying now that it doesn't, or?
Yeah, let me clarify. What I was trying to say was, I think the fair and impartial policing policies that we have are in line with the intent of this piece of legislation. Those are focused specifically on law enforcement agencies, whereas this bill is focused on the administration officials. And I was using that as an example of the type of policies that I think can be helpful. And I think exactly what you're saying, that having some of those protections in place fosters greater trust between law enforcement and the communities that they are serving. And so, sorry if I misspoke there, but I was trying to lift that up as an example of where the state has done work like this in the past, where we continue to butt up against where the limitations under federal law, because as we all know that under the Supremacy Clause, federal law controls, and we cannot override federal law as a state. But that was not meant to be, mostly meant to be an example of where we've done similar work in the past. So I think looking at the fair and impartial policing laws or policies at some point and how they're being operationalized could be a helpful thing for this committee to think about just moving forward as opposed to. So I think that's something worth looking into, just how they're working on the ground now. But I hope that answers your question.
Thank you for your clarification on IS.
Any further questions? Falco, I think you touched on it earlier. I just want to make sure I'm fully understanding. I mean, my concern remains with 1373, and I'm looking at your proposal that's highlighted in red, phase 2, subsection E. And so was it? So are you suggesting that in everything that's in subsection C below that would avoid the issues that we could encounter with 1373?
Yeah, I look at the underlying existing law, so subsection E of 4651 states that nothing in this section is intended to prohibit or impede any public agency from complying with the lawful requirements of 8 U.S.C. 1373, 1364, and to an extent a state or local law enforcement policy or practice conflicts with the lawful requirements, the policy in practice and the extent of such conflict is abolished. So in terms of state and federal agencies interpreting this, that's existing in current law when it relates to those limitations. So I think that we are not proposing to modify that in any way, but that is a safeguard that was put in place in 2017 when the original law was passed to try and make sure that as folks might get close to that line, we're making sure it's explicit. We are not prohibiting the sharing of information related to immigration status. And those statutes are pretty limited, very specifically focused on information relating to immigration status. So there might be other pieces of information that are not that, which the state might withhold lawfully. But we're not saying that we're explicitly not asking the state to violate the federal statute.
Thank you. Anything else? Okay, sure. Thank you, Paul.
Thank you so much.
Okay, next up we have Jay.
You. Thank you, Mr. Chair. Thank you for having me today. For the record, Jay Perkin Johnson, Governor's Legal Counsel. Again, thank you for inviting me today. So my remarks are fairly short. I just have a couple of quick points to make on S44, which prohibits the governor from entering into certain agreements with the federal government for the enforcement of federal immigration law. First, I just want to point out again, I always sort of go back to the organic principles and separation of powers. Section 20 of Chapter 2 of the Vermont Constitution charges the governor with the faithful execution of the laws and with transacting business with officers of government, civil and military. The micromanagement in this bill undermines the Constitution's purpose of giving this power to the governor in the first place. This may be an unconstitutional encroachment on the governor's authority. It's our position. Second, I understand this bill is motivated by the fear and anger that many feel as a result of the rhetoric and recent actions at the federal level. I understand this need to do something. I feel a flailing with its understanding that we need to react in some way. But I don't think that it's wise, and I think it's the governor's position, that we don't need to add fuel to the fire. We did go through this, as Bethel mentioned, and I believe others have mentioned, in 2017. And the law that we're trying to change today is the law that was passed in 2017 to address the same concerns and the same fears. And in 2017, we had bipartisan support, and we celebrated these changes that we made together. It makes no sense now, in my view, to signal resistance to federal policy with a demonstration of our own constitutional overreach. I believe we can work together and we can do better together. So that's it.
Thank you. 1 second, Senator Ruth. I did just want to first highlight I'm just speaking from my own position on this. I think it's pretty clear that the bill as it's written is not something that the governor would sign. That's my opinion. I do think that, based on what you just stated regarding collaborating and trying to, collaborating, it's my thought that we can try to find potentially any changes that may create better protections for migrant communities in Vermont. And I think that when there is a large amount of our constituencies, or at least my constituents, reaching out to me to request some sort of changes, it warrants starting the conversation at least. And so, yeah, I mean, it's just my hope that we can potentially find some areas that we could find consensus on, that we could change policies to better protect migrants in Vermont. So that's my position. Senator Bruce.
Agreed. And I also agree, Jay, with what you said about the need to do something. And so people sometimes don't act as long-term or long-range as they should. But I am wondering, the suggestion that Falco brought forward, which is to eliminate this clause under this one.
With respect to the sheriffs and the exigent circumstances.
Right. So my reading of it is that the A clause gives the authority to the governor in consultation with the attorney general, the exclusive power to enter into these agreements, which I very much agree with, because the concern is, random law enforcement agencies that might be sympathetic to and what we consider an overreach by the federal government. So that second B clause says, when necessary to address threats to the public safety or welfare of Vermont residents arising out of the declaration of a state or national emergency, as Falco said, the president has gotten into the business of issuing emergency orders around what seem to be very general policy views of what's happening, not what we traditionally consider an emergency. So if we were to eliminate that clause, it seems to me we don't run afoul of the governor's constitutional powers, because we're affirming them by getting rid of the power of other agencies to go against the governor's authority because of the federal emergency. Does that make sense?
Yes, it makes sense what you're suggesting. I
Okay,
mean,
just wondering.
I understand the concept. I mean, I think you would want to hear from sheriffs and other law enforcement agencies about the power that they have to do this in the first place.
Yeah.
I am always a little concerned about the approach that starts with the solution in search of the problem. The problem seems to be this idea that we need to do better. And I don't know that there's evidence from the last 8 years that we have not done better. I don't know that we've seen evidence that law enforcement and or the governor are inclined to take actions like you're suggesting that we need to take. So I guess I would want to hear from other law enforcement, sheriffs, others who may feel that in exigent circumstances, they need this authority, what those circumstances might be. This was all pretty well contemplated in 2017. So I guess I would just want to hear more testimony. I'm certainly not the person who can make a determination about. I mean, I can say that I don't believe that taking that out would be unconstitutional. So is that an objection that I could not live with? I mean, I probably, if it wasn't there in the first place, that's consideration, that's a policy consideration.
Yeah.
But I would want to hear from others and what sort of the pros and cons might be to making that change.
Well, and clearly we will.
And whether Vermonters are better protected is a question.
I was just asking your opinion. I appreciate I also think that it wouldn't be unconstitutional to remove this. I will say, I don't think the problem is that we want to do better. I think that's the hope, is that we want to do better. The problem is that we have an administration now that is clearly within weeks of taking power is seeking to recast the understanding of federal power, executive power across the country. So I think being proactive is not necessarily an overreaction. It's obviously necessary to me, given what's coming out of the White House. So this is a place where I feel like we could do no harm to the existing statute, but protect ourselves against what seemed to me to be, kind of created emergencies that give the federal power sweeping authority.
Understand.
Senator Wilson? Committee, any further questions now? Okay. Well, thank you, Jay. I think it's going to be a conversation that's ongoing. The hope is to hear from the sheriffs, DOC, and towns, if we're making changes that affect towns as well. And just hoping that you'll continue to be a part of the conversation as we hopefully approach something that might be passable.
Sure.
Okay.
I will. I'm happy to become part of the conversation. Thank you.
Have Commissioner Demmel on the list, but I don't, is he?
He is available at 10, but
Chris Brickell or Brickle? Is he also in Zoom or later on?
he is not on Zoom, and I was expecting to see him via Zoom, but I just am not sure if it's going to be at the moment.
Okay, we can have the Attorney General's.
Thank you, Chair, for the record. Todd Delos from the Attorney General's office. I apologize. I'm going to have to step out in 10 minutes, but I will come back as quickly as possible to answer further questions if the committee has them. In brief, we take the same position as the Governor's Council on this. We don't believe that there is a need for this as drafted as 44 legislation. We haven't heard of, we're not actually even aware of any agreements that have taken place under the existing statute. And we believe that removing the Attorney General's role and the Governor's role from this work will not forward the needs of law enforcement in this space and at this time. Certainly hear what Senator Baruth said about the exigent circumstances and would welcome further testimony from law enforcement officials on that point. That's broadly the position of the AG's office on this. I would go further and say, I think what the ACLU raised is also a really important point, that the fair and impartial policing policy we believe is doing its job, already prevents this kind of cooperative agreement. And the CJC's work on that has already forbidden law enforcement from participating in civil immigration enforcement. So we feel like the protections that exist now have held, are good in place, and that the system that came out of the 2017 legislation works and holds. We have some other more granular and detailed concerns with the way that the statute's drafted, specifically relating to some of our main law enforcement work around the Internet Crimes Against Children Task Force. The way the bill is drafted and a focus on 19 USC 1401 would largely undercut our ability to do that work. That work is housed and focuses on Homeland Security. That's where the servers are. That's where all the computer. I don't want to wade into it too much. We can bring in the detectives to talk about it, but by and large, we would then have to cease the work of ICAP and go through a pretty long and arduous process to stand that work back up, because this focuses on not just border protection under 8 USC, but customs under 19 USC. And so, again, that's a more specific granular concern. On the broad level, we don't see a challenge ahead that this bill would solve that doesn't already exist with the governor's support.
Could you just share a bit more information, or at least differentiate between border issues versus customs issues, and how just that it seems like there's two paths there, two categories. Can you?
Very simply, border issues are people, customs issues are things. And when we're looking at the Internet Crimes Against Children work, those are things moving across borders, and we need the ability to go after those perpetrators who are harming children.
I would agree with that. Where do you happen to know off the top of your head which section
It's
page and line that?
Yeah, it's the 19 USC 1401.
1401. Senator Wilson.
So I appreciate that the language as it is, it's not potentially solving the problem we're trying to solve. I would not agree with any characterization that there isn't a problem to solve. And I also recognize that, you probably just saw this language if you've seen it at all, but I wonder if you have any thoughts on the recommended changes from the ACLU.
Unfortunately, this is as close as I've gotten to the language from the
Okay.
ACLU. So I'm happy to look at it and come back if
Okay.
that's helpful or submit comments. And happy to connect with help.
That would be really helpful, because I do know that we have heard testimony from the people who are afraid and the people who are, right now being moved through detention facilities. And so I think there is absolutely work to be done, particularly, the rhetoric is different than in 2017. So I think belts and suspenders make sense.
And I think I appreciate I will call it a friendly correction, Senator. I think, what Jay said at the time is also true for us. We recognize there's a lot of fear. And a lot of that fear comes from a lack of clarity. And this is a space where we feel the safeguards put in place in 2017 are adequate to meet the moment. And we are ready to continue wading into that space if we see, an increase in actions that are contrary to what this is.
Committee, any other questions? Senator North.
Yes, I have a few questions, short, hopefully. Under 1401, it's my understanding that, I agree with customs versus immigration. We're not dealing with people, we're dealing with things. The elimination of ICAC to work with HSI would be detrimental to the state of Vermont and victims within the state of Vermont simply dealing with it. And HSI has things that they offer to the ICAC division. They actually lose the personnel. This was enacted as presented.
I can't answer that absolutely. I think what we would lose is access to a lot of the technology and technical support that makes this work possible. I would have to look at the funding question around whether our personnel will be lost. I mean, certainly if we were to enter into an agreement, and I should say the agreement that ICAP currently has with HSI predates the law. It was a 2016 agreement. So that's why it hasn't actually gone through this process. And that's why this issue hasn't come up until this proposed amendment. But I'm happy to get back to you on a loss of personnel. I'm sure I can get back to that.
And I know you gotta go in like 3 minutes, Todd. I've heard comments in reference to just how much weight does the present law have that says that the governor has to consult with the AG's office, and then anything from, okay, well, I called it and we're moving on now. Can you give us your interpretation of what that means exactly?
I think we often include, this body often includes consultation as an element of good governance and decision-making, shared decision-making. And I think we are confident in the relationship between governor's council, certainly governor's staff, and the AG's office to be deeply engaged in any kind of conversation around this. At the end of the day, the authority under the bill is granted to the governor. And so we would continue to consult with the governor, provide our advice, and the governor would make the decision.
Okay, thank you.
Senator Bowles.
I do just want to sort of bring up a point that I have made before, and that is that we shouldn't be legislating to an individual person in an office. It's fantastic that this AG and this governor have a relationship where that feels like it would be good and productive, and we don't know that that will always be true. And so I think we need to really be thoughtful when we're making laws that they're not based on a specific relationship that works or a specific person that does things a certain way. So I appreciate that relationship, and that may not always be the case.
Understood. Appreciate it.
You look like you're about to raise your hand.
Yeah, I was just gonna say, doesn't this bill legislate to a single person?
No, it passes a law that says the way the relationship should works that way. When we're starting to talk about, we don't need this because this governor has a great relationship with the AG.
I'm talking about federal. Isn't that what this bill, the overarching idea of it is
This bill is responding
Person at the
to
top.
threats that are coming down. And if those threats are not coming down, then this bill will still not be harmful. Like, there are very real concerns that people have and threats that people are under that, yes, are because of this administration. But this is a blanket protection. It's not relying on a good relationship for not doing something or doing something.
I just, from my perspective, it was addressed in 2017.
Thank you for your testimony.
Appreciate it.
This guy, come on.
I- So Director Raquel is on Zoom, so.
He is president.
Good morning. Is your, just to clarify, is your last name Raquel or I just want to pronounce it correctly.
It is, Senator. His last name is Burkell.
Good morning. Thank you. The floor is yours. Please introduce yourself and happy to hear your testimony.
Thank you. For the record, Christopher Burkell, I'm the Executive Director of the Vermont Criminal Justice Council. I've looked at this proposal, and quite honestly, I think that the VCJC is not exactly the best position to have any comment on this proposed legislation, other than to say that, and also hearing a little bit of this testimony, is that we also recognize the fear and uncertainty out there in the communities, and that a lot of that fear has been hopefully addressed by the revisions of the latest version of the fair and impartial policing policy that's mandated statewide. Was done so in 2024 with stakeholders, with migrant justice, with ACLU, Human Rights Commission, a lot of folks that had a lot of input on this. And I think that where we hold folks responsible is in making sure that they adhere to that policy and making sure that there's that understanding of what Vermont communities want for law enforcement to be working, and keep making sure that relationships are good with communities that might have those fear-based, and making sure that they also understand that federal civil immigration is an authority of just that, federal authorities and not Vermont authorities, and that's not their perspective to be worrying about. So I think from our perspective, I think the policy is strong thus far. We haven't had any real issues or concerns that have been raised to us other than the unknown and where folks think that things might head. And what we keep trying to push out to folks is like, we're not going to worry about circumstances that have not presented themselves yet. We keep pushing out to Vermont law enforcement what their priorities should be. And I think it's pretty clear that Vermont law enforcement authorities don't want to have that negative interaction with their communities that they're serving.
Thank you. And just to put on the record, both for the committee and for folks who might be listening, can you just give us the overview of what some of the changes were to the fair and impartial policing policy in 2024 that strengthens that policy, please?
So there were differences outlining very clear the difference between civil immigration and federal civil immigration and federal criminal investigation type of work, what Vermont law enforcement should and should not be doing, making sure that they also know that federal civil immigration is a federal responsibility and not a Vermont law enforcement responsibility. Also worked on building community relationships and understanding the differences between when contact with federal authorities is appropriate and reasonable within some of the things that they interact with on a regular basis. Now, most folks don't realize that largely for the state of Vermont, most law enforcement doesn't regularly deal with federal authorities. That's different on the bordering, locations within the state, but that's a very small population of law enforcement that actually interacts with federal authorities on a regular basis. So we want to be clear with those agencies that don't, that this is still their responsibility to understand, because this interactions could happen anywhere within the state.
And Senator Mosley, did you have a question?
Yeah, is every law enforcement agency, have they all adopted at this point the new fair and impartial policing policy and in compliance with it and trained on it?
Almost all. There is the exception of two constabulatories that we're making sure that their policies are compliant. They largely are, but for some of the language that they haven't adopted. And then two communities that we're still working with on one that has language that has found to have been non-compliant that we and the Attorney General's office are working with to make sure that that language becomes compliant. And then one other community that has adopted the council's policy. However, they have an ordinance that offers some more protections. So there is discussion about which takes precedence and whether an ordinance would in fact hold more legal grounding than a policy issued by the department. So those are again consultations that we have ongoing with the Attorney General's office and that community.
Right, that's really helpful. Thank you. And so there is it sounds like the question there is whether the ordinance, which may have the rule of law, is more binding than a policy.
Well, it all depends. So a policy is enacted by the police department and that's the policy that they follow. However, if their town has an ordinance and it covers all of those towns' employees, then that ordinance holds preference, I would believe, over what the policy would be. So there's that conflict there that we're trying to resolve. And I assume that it's going to be resolved to everyone's satisfaction. It's just a matter of legalities that the Attorney General's office is looking into and providing some guidance for us on.
Awesome. And just to be clear, the ordinance is more protective?
The ordinance has some protections in there that conflict with the fair and impartial policing policy.
One last question. If an agency is out of compliance with the fair and impartial policing policy, willfully out of compliance, what would the ramifications be?
If they're willfully out of compliance, two things. One is by statute, the fair and impartial policing policy of the council takes precedence, but they would also lose their access to services of the Vermont Criminal Justice Council. So they would not be able to use any services that we provide.
Thank you.
Speaking to that last point, just for clarification, that is a final step that we would take. Our first charge is to work with those communities to gain compliance and make sure that the policy does follow the council's policy.
Thank you. Senator Norris, Senator Mosley.
Yes, good morning, Director. The question that I have is I had seen policies come to the Vermont Criminal Justice Council in reference to mandatory adoption. And if they don't adopt by a certain date, they would assume that they have adopted this policy. Was the fair and impartial policing policy one of those that set a date that if you don't officially adopt, it's considered to be adopted by all law enforcement agencies throughout the state?
I honestly can't answer if that had a specific date to it, but yes, the end result was that in fact, they have adopted the council policy and that they have to fully enforce the council policy.
Thank you.
There was a time frame when we just updated the last policy, which was, I believe, in April of 2024, that we had given a time frame for agencies to become compliant because we have that additional responsibility of making sure in consultation with the Attorney General's office that all of those policies for each municipality and were compliant with the language that we had.
Thank you.
And so it's my understanding that the state law allows for agencies to have stronger protections than the policy. Is that true?
That is true. They can offer additional protections so long as they don't conflict with the federal requirements that are in the statute.
Okay, and are there, to your knowledge, presently any of our agencies that have stronger protections than the fair and impartial policing policy?
I'm not aware specifically of certain municipalities that or agencies that have additional protections. There may be some, but those would have been vetted by the Attorney General's office to make sure that they were still, again, compliant with federal law.
Okay. Okay. Thanks.
Any further questions or comments? Thank you. I appreciate your testimony.
Thank you.
Can I just ask this, but Commissioner Dowell, what was his plan again?
Is that a speaking engagement?
Yeah, yeah,
Right, okay.
yeah, he'll be over shortly after. It's in Montpelier. So.
Okay, sounds good. We can, let's take 15 minutes and then come back at 10:05. This is what you're planning,